Real Estate License Exams for Dummies. Part 3 is All Mine, Owning and Transferring Real Estate. Chapter 7, Understanding Forms in Real Estate Ownership. In this chapter, finding out about owning real estate alone and with others. Checking out special ownership of cooperatives, condominiums, and more. Chapter 7, Understanding Forms in Real Estate Ownership. Real estate ownership comes in many forms. You can own real estate by yourself. You can own it with your spouse. You can own it with a partner. You can be part of a corporation that owns real estate. You also may own real estate in the form of a condominium or a cooperative. In each of these situations, ownership issues, forms are slightly different. Attorneys usually handle the form of ownership of a property. In some states, especially those where attorneys are less involved in real estate transactions, you may, as an agent, have to deal more directly with these issues. And speaking of states, there may be slight differences from state to state with respect to some of these forms of ownership. Pay attention in class and note anything that might be unique to your state. Regardless of how much you're involved in a form of ownership issues in real estate transactions, state examiners expect you to know something about the various types of ownership. In this chapter, I give you some basic terminology and key features of the various forms of real estate ownership, such as owning property by yourself, with others, with a spouse, and in trust, and in a business. I also cover special types of ownership, such as cooperatives and condominiums. Even in states where real estate agents do most of the work associated with buying and selling properties, agents always need to be aware of the things with which they are not familiar. When the ownership matters gets the least bit complicated with regards to forms, they need to and can refer clients to customers to attorneys skilled in real estate matters. Real estate ownership, solo or group activity. The real estate can be owned by one person, two or many people, a married couple, or some type of business is obvious. Because as real estate law evolves, it has to deal with the various forms of ownership from different terminology and sometimes different conditions. In this section, pay particular attention to the terminology and key differences among the various forms of ownership. Exam questions on the subject are likely to be focused on recognizing these differences. You see the word tenancy throughout this section. Tenancy means having an interest in a piece of real estate. Most of us associated with the word being a tenant, which essentially is what it means. However, it also means having an ownership interest in the property. On a state exam, you see the word used in both its meanings. By the way, the word tenancy comes from the Latin word which means to hold. One is the loneliest number. Owning real estate by yourself. Owning real estate by yourself is called sole ownership or tenancy in severity. I know the law has done it again. Right about now, you're asking, how can you use the word severity when it only means one person? The answer actually is pretty logical if you remember one thing. The word severity doesn't come from several, but rather the word sever, which means to cut off. Severed, which means to cut off. Sole ownership cuts off all other interests in the property. In other words, no one has an ownership interest in the property except the owner. Join the crowd. Owning real estate with other people. Two or more people who aren't married, and can own property together is a form of ownership known as concurrent ownership or co-ownership. I describe two forms of co-ownership tenancies in common and joint tenancy. Although these two similar forms of ownership are available to married couples, they may serve specific purposes of ownership for people who are not married but want to own property together. Tenancy in common. Tenancy in common is a form of ownership in which two or more people own property together. The fact that two or more people are buying property together as tenants in common is stated in the deed. In some states, if this form of ownership isn't otherwise specifically stated in the deed, tenancy in common automatically is assumed when two or more people buy property together. For general information about deeds, check Chapter 9. Probably the most common form of ownership where tenancy in common takes place is condominium ownership. See the section More Individuals, Condominium Ownership, later in this chapter. The principal feature of tenancy in commons are undivided ownership. The land itself, if not physically divided into or split between multiple owners, but rather a percentage or share of interest are granted to the property as a whole. Equal or unequal shares. The percentage of ownership interest of each party needs to be equal. So one person can have a 50% share and two other people can have 25% share the same, and so on. Sale without permission. Any owner can sell his or her shares without having to receive permission to do so from the other owners. The new owner is a tenant in common with the previous owners. No right to survivorship. If one owner dies, she leaves her shares to her heirs. The other owners don't have any rights to her shares of the property. Tenancy in common might be the way two married sisters buy a vacation home to share. If one dies, her husband and children would inherit her part of the property. If one sister has more money invested than the other, there will be no problem because one would own, say, 60% of the property, whereas the other owned 40%. Joint tenancy. Joint tenancy is a form of ownership with several features or two or more people. Joint tenancy is said to be created with these four unities. Unity of interest. Unity of interest means that each owner has the same interest in the property. If there are four owners, each has 25% share in the whole property. If there are two owners, each has 50% share. Some states now permit unequal shares in joint tenancy. You should check out what the law is in your state. Unity of possession. Like tenancy in common, see in previous section, each owner interest is in an undivided property. Although interest in the property may be divided, the land and building, if any, may not be divided. In other words, no physical divide of the property exists. Each owner essentially owns a share of the property as a whole. Unity of time. Joint owners all take title of ownership of the property at the same time, and later owners can't be added to a joint tenancy as a joint tenant unless new documents are executed, effectively creating a new joint tenancy. If one of the joint tenancies sells her interest without this happening, the new member becomes a tenant in common. A joint tenant also may sell his individual interest without the permission of the other joint tenants. Unity of title. Unity of title means that all of the joint tenants' names are on the deed together. Any brother and sister who wants to own a home together could buy a property as a joint tenants. If one dies, the other automatically takes ownership of the whole property. Perhaps the most important difference between joint tenancy and tenancy in common is the right of survivorship that you have to joint tenancies you don't have in tenant in common. The right of survivorship in joint tenancy means that if one of your joint tenants dies, the other tenants automatically takes title to the deceased tenant's interest in the property. For example, if four joint tenants each own 25% share of a piece of property, and one joint tenant dies, the three remaining tenants each has a 33 and a third percentage share. That's why joint tenancy is a form of ownership that married couples sometimes use when they buy property. When one spouse dies, the other spouse automatically gets full title of the property. You may want to check whether your state still recognizes the right of survivorship in joint tenancy. Some states are doing away with the aspect in this type of ownership unless it's specified and stated. Getting hitched. Owning real estate when you're married. The law over time has developed special forms of real estate ownership for married couples. I describe the two common forms: tenancy by the entirety and community property, one or both of which may be available in your state. Tenancy by the entirety. Tenancy by the entirety is a form of co-ownership, especially geared towards protecting the interests of married couples by providing a right of survivorship. A form of joint tenancy, see the previous section for all the full scope. The theory behind tenancy in the entirety is that the couple is treated as if one person owning property is so far as each spouse has an individual and equal interest in the property. Upon the death of one spouse, the deceased spouse's interest automatically goes to the surviving spouse without having to go through the process of probating a will or other inherited issues. Another unique feature of tenancy by the entirety is that neither spouse can sell his or her share without doing so together. The entire property must be sold by the combined actions of both parties signing the deed. In the event of a divorce, a tenancy by entirety is changed to a tenancy in common. See tenancy in common early in this chapter for details. Community property. Some states operate under the community property laws. Under these laws, all property that a couple acquires during their marriage is considered jointly owned and equally owned by both spouses, regardless of who actually income was used to purchase the property. Property acquired by one or the other spouse before the marriage is called separate property and is not subject to community property requirements. Property inherited during the marriage by one or the other spouse is also considered separate property. The essential element of common property law are: community property may be sold or mortgaged only by joint actions of both spouses. Separate property can be sold or mortgaged by a person owning it or bringing it to the marriage. No right of survivorship exists. Upon the death of one spouse, the surviving spouse retains title to his or her half of the property. The deceased spouse's half interest can be willed to anyone. You need to check how real estate ownership of married couples is treated in your state. Laws may vary from one state to another, particularly with respect to the specific implementation of laws protecting the rights of married couples in real estate ownership, and whether the community property is recognized concept. Other states, for example, may use joint tenancy with the right of survivorship for married couples. Who do you trust? Ownership and trust. A third party can hold real estate for the benefit for someone else. The main players are the trustor, the person who owns the property and conveys it to the trustee. The trustee is the person who receives the property and administers it on behalf of the beneficiary. And the beneficiary is the person who receives the benefits of the property, like rent on an apartment house as a result of the administration of the property by the trustee. You leave your apartment building to your brother in trust for your favorite nephew. You are the trustor because you created the trust. Your brother is the trustee and he administers the building according to the terms of the trust. which is in this case will likely be that the income from the building goes to your nephew because he is the beneficiary. Ownership in trust requires a special type of deed called, you guessed it, a trust deed or deed in trust. For more, see Chapter 9. All business. Ownership by a business. Ownership of real estate by a business organization is not so much about the form of ownership as it is about the organizational structure of the business. You're not likely to be involved very often with this type of transaction in your everyday real estate practices, unless you work as a great deal of commercial real estate developers. State examiners, however, expect you to know something about the different business organizations and how they can own property. You may hear the word syndicate in connection with the business projects. A syndicate isn't a form of ownership. It's a term generally describes two or more people or companies joining together to work on a project or form an ongoing relationship to own and manage buildings or other real estate. Businesses and syndicates are purchased property as investments. For more about investment property and forms of investment ownership, see Chapter 17. Corporations. A corporation for a legal purpose is treated the same as an individual owner when it comes to real estate ownership. Generally speaking, unless the corporation is involved in co-ownership arrangements with another corporation, it owns property in sole ownership or tenancy and severity. It discussed in tenancy and severity in one of the loneliest number, owning real estate by yourself, early in this chapter. A key feature of real estate ownership by a corporation follow. People own shares of corporation, but no direct ownership exists for individual shareholders in property owned by the corporation. Shareholders have neither authority nor responsibility for management of corporation property. Shareholders' liability generally is limited to the value of the shareholder's shares. For instance, if a shareholder owns $1,000 worth of stock in a real estate investment corporation and the company loses a lawsuit for millions of dollars, regardless of whether the corporation has the money, the shareholder can only lose his $1,000 investment and no more than that. It should be noted that this protection is subject to court rulings in the event of a lawsuit. Profits the corporation receives from the property are taxed before they're distributed to shareholders, who then pay taxes again on the amount they receive. The so-called S corporation is a formal corporation with modified tax liabilities and is permitted by the government under strict rules. Partnership. A partner is two or more people or companies combining to do business. A partnership may be short-term for one project like buying, renovating, and selling a building, or a long-term for ongoing investments and management of real estate holdings. Many states have adopted the Uniform Partnership Act and the Uniform Limited Partnership Act, which allows real estate to be owned in general or limited partnerships. Partnerships are neither general or limited. Partnerships are either general or limited. In general partnerships, all the partners share in the management and operational decisions over the business of a partnership. They also share in the liabilities of any actions the partnership takes without limit. The respective partners pay taxes according to their respective interests and liabilities, so that double taxation is avoided. On the other hand, in a limited partnership, one general partner usually manages the operations of the business, and a number of other limited partners have no management responsibilities. The liability of the limited partners are determined by and limited to the amount of the respective investments in the company. Limited liability corporations. The limited liability corporation, LLC, or limited liability company, as it is sometimes called, as a hybrid organizational structure that has elements of a partnership and of a corporation. Similar to a corporation, the liability of the individual members within the corporation is limited. Meanwhile, they pay taxes as if they are part of a general partnership. See the previous section. Management by members of the LLC also may be along the more direct lines allowed in a general partnership. Joint ventures. A joint venture is a joining together of two or more people or companies to do a single project, like buy a house, renovate it, and sell it for a profit. A joint venture is somewhat like a syndicate in that it can own property in any of the several forms, like a tenancy in common, joint tenancy, or a corporation, among others. See the section on these forms early in the chapter. However, ownership probably will include an ending date because joint ventures are designed to be ongoing business relationships. A joint venture, like a syndicate, is really a name or two more is really a name of two or more people or companies who want to cooperate in a real estate investment. The difference between a joint venture and a syndicate is that a joint venture brings people together for one real estate investment or project, whereas the syndicate usually does multiple real estate investments or projects at the same time, or a series of individual projects over a period of time. Special type of ownership. Cooperatives, condominiums, and more. Cooperatives and condominiums are popular forms of ownership for a variety of reasons, but primarily because they usually are built to a higher density, more units per acre, or a high-rise building, and they're often somewhat less expensive than a single-family house in the same area. Provide some of the advantages of ownership, such as building up equity by paying off a mortgage, and tax advantages like being able to deduct the real estate taxes and mortgage interest. I cover mortgages in chapter 15 and taxes in chapter 16. Provide the advantage of no outside maintenance because the dwelling usually are maintained by the ownership association in the case of condominiums, or a board in the case of cooperatives. These forms of ownerships are unique because they involve ownership by more than one person, but the owners aren't known to each other, nor are they in a business venture together. I cover cooperatives and condominiums, plus planned unit developments and timeshares in the following sections. Share and share alike. Cooperative ownership. Strictly speaking, you don't own real estate when you're part of a cooperative. You own shares in the corporation that owns the real estate. As a shareholder, you receive a proprietary lease that enables you to occupy your apartment. For all intents and purposes, your ownership interest in a cooperative is treated like real estate, including the ability to finance your purchase just like a mortgage, except that your shares and not the property itself are pledged as collateral for the loan. In other words, if you can't pay off the loan, the bank can claim your cooperative shares and payment. For more about mortgages, see chapter 15. Some of these expenses are deductible from annual personal income taxes, such as a cooperative ownership share of the property taxes. The board of directors of a corporation makes rules and policies for the building, collects monthly fees and shareholders and maintenance the building, and pay the taxes and other expenses that may exist, like emergency repairs and a mortgage on the building itself. This mortgage on the building is generally referred to as an underlying mortgage and can sometimes make the monthly common charge a little more expensive than a condominium because the share owners are responsible for payments on the underlying mortgage. Two issues that frequently are considered disadvantages of cooperative ownerships are shared liability. Whenever shareholders default on their common charges, the payments all shareholders make to maintain the building and pay taxes, the other paying shareholders are liable. This issue can become serious whenever too many shareholders default on their payment, and the other shareholders have to pay the share of the money that wasn't paid by the defaulting shareholder. Cooperative board approval of newcomers. This issue may be viewed as a negative or a positive depending on your point of view. Requiring board approval of new cooperative buyers whenever someone sells their share in a cooperative is fairly common practice. The requirement allows new owners to be screened for financial ability to pay their loan and common charges, but it also holds up to the sale of a unit while a prospective buyer undergoes the board approval process. Cooperative boards in many places may not be required to reveal the reason they turned down a specific buyer. Insufficient financial ability in general is the best reason to turn a buyer down, but other reasons, including illegal ones such as fair housing violation, may exist despite the fact that the cooperative boards are subjected to these laws. More individuality. Condominium ownership. Condominium ownership is a form of group ownership that involves actual getting a deed to your individual ownership interest. In general, the deed describes the airspace you own, in other words, the unit, which you own as a tenant in severity, and your shares of the tenant in common, and of the land under the ground of your unit. See Tenancy in Common section earlier in this chapter for details. A homeowner association that usually collects set monthly fees, which pays for maintenance of the condominium building and complex. Individual condo owners are responsible for paying their own property taxes, so defaulting on your taxes obligation can result in a foreclosure on the unit but not the entire complex. For more about foreclosure, see Chapter 15. Condominiums often are associated with complexes in the suburbs and are thought of as a low-rise one and two-story attached housing units. Condominiums, however, may also be found in high-rise buildings in urban areas. You need to find out what your term townhouse means in your home state. Originally a term used to describe 2- or 3-story attached housing in urban areas, townhouses now are usually located in planned units development. Typically, a townhouse owner owns the unit and the land under it, and may even have ownership of a small lawn or patio space, because many earlier condos were built in 2-story townhouse styles. In some areas, common usage occasionally mixes the term, called condominium townhouses, regardless of the style. Mix it up. Planned unit developments. The planned unit development, PUD, is a somewhat hybrid of ownership. In theory, the PUD is a large development often having mixed uses, such as different types of residential and commercial uses. The building by a single developer. In practice, a pub may have only residential uses like a condominium. Pubs also are overseen by homeowner associations. Common charges paid by the homeowner go for the outside maintenance. How a pub often differs from a condominium is that the owner of a pub unit also owns the land beneath it. In a condominium, you own the unit individually, but the land underneath and around it as a tenant in common with others. See this section of Tenancy in Common earlier in the chapter. You generally don't own the land individually in a condominium. You usually do in a pub. You also usually own so-called common areas like recreational facilities, walking paths, and internal roads as a tenant in common with others, just like a condominium. You should find out how the term pub is used in your home state with respect to developments and property ownership. Check your watch. Timeshares. In a timeshare, a person has either a factual ownership in the property or the right to use property for a limited period of time each year, or both. Ownership in timeshares may actually convey a fee simple ownership interest in the property. In other words, you have an unlimited rights to the extent of your ownership interest. Even that ownership interest is the last 2 weeks in August every year. For more about fee simple ownerships, see Chapter 6. A timeshare owner may only have a use interest, which is permitted to use the unit on a periodic basis, which as first week in June each year. A person with a timeshare use interest, in other words, the right to use the dwelling for a defined amount of time, leaves ownership of the property in the hands of a corporation or individual. And that was part 3. It's all minds. Owning and transferring real estate. Chapter 7. Understanding forms of real estate ownership. Thank you very much.